Ladies and gentlemen, welcome at this webinar organized by Deltalinks with law firm NautaDutilh about legal issues in the Port of Rotterdam. Let me first introduce myself, and after that I will introduce our interesting speakers today. Well, my name is Bas Jansen, I'm Managing Director of Deltalinks, and Deltalinks is the Port and Industry Association here in Rotterdam. We represent a number of companies, about 700 direct and indirect, and also a lot of service providers, like law firms, like NautaDutilh. We are very happy that they are in our group because they have special knowledge about what's happening in the Port of Rotterdam, especially on legal affairs. We have an interesting number of speakers, which I will introduce before their presentation. As Deltalinks, we focus on the transitions like the economic transition, the climate issue, digitization, the social transition. A number of new workers are needed, technical skills, ICT skills, and also our license to operate. We, as we say, are the motor of the economy in the Netherlands. So therefore, our legal situation is very important. We also focus on accessibility and infrastructure, on environmental issues, safety and security issues, and of course also the problems of drug traffic and all kind of criminality which we want to prevent. But now I will give the floor to our colleagues here in the room, and I will give the floor to Iris Kieft. Iris is a partner in public law and the regulatory group. She specialized in environmental law, sustainability and the circular economy, and of course climate change. She focused on the energy and infrastructure and the industry sectors. So may I introduce Iris and give the floor to you.
Thanks, Bas. Happy to be here today. If I can move to the first slide and see if it's, yeah, this one. Following what Bas was saying, the Port of Rotterdam and the parties that are active there have great ambitions for the energy transition and the climate challenges, I guess, we are facing. And the Port of Rotterdam has, as you can see from the different sort of headings that we've collected on this slide, issued the intention to be a 55% or to achieve 55% CO2 emission reduction by 2030 and become CO2 neutral by 2050, which is in line with the targets of the EU climate law, which have been set at the EU level. And so what we want to do with you today here, and I'll move to the program, is to discuss three legal aspects which are relevant for activities that are happening in the port, and in particular for the energy transition or the climate adaptation initiatives that are being developed. Many of the participants today are not from the Netherlands, so we'll start with the basics. So for those of you who are from the Netherlands and may be already familiar with some of the basics, please bear with us and ask your questions. We'll have some time for questions as well at the end of the webinar, so please feel free to ask more detailed questions. We're happy to answer those. So what I will do today is discuss with you the regulatory landscape and some regulatory challenges that are specific to the Netherlands and the Port of Rotterdam. So for the regulatory landscape, I just wanted to walk you through if you do activities in the port, or if you have initiatives that you want to make happen in the port, then environmental regulations come at you from many different levels. They interact and influence each other, and thought it would be useful to get to understand the overview. So I'll go from bottom left along the top to bottom right. First with the EU level. So at the EU level there is certain types of legislative instruments called regulations that apply directly in the Dutch legal order. And examples of those are, for example, the shipment of waste regulation, the Climate Act, which sets the CO2 emission reduction objectives that we just discussed, the REACH regulation, which regulates the use and marketing of chemical substances, But also, for example, the free allocation rules, which determine under the EU ETS whether you are eligible for free allocation of emission allowances. Those rules apply directly, and at the national level there might be some sort of implementation for administrative purposes or sort of procedural purposes and for sanctions, but the actual environmental rules are set at the European level and they apply directly. Then we move to the national government. At the national level, various things happen. On the one hand, there's implementation of many European environmental regulations, directives that also apply in the Netherlands but have to be implemented in the Dutch legal order. And as just discussed, some sanction mechanisms or procedural aspects of other European legislative instruments. The main national environmental law in the Netherlands is the Environment and Planning Act, which is a very new law. It has been in effect since the 1st of January of this year, and we are in a transitional phase. So that means on the one hand that we still apply the old law, the old framework for procedures that were already in play when the new law entered into force. And that when we start new initiatives only now, then we look into the new legal framework. So both are relevant at the same time. And in relation to the new legal framework, everyone is trying to figure out how it works and what that means. So that means that there is sort of an additional uncertainty for getting any sort of project permitted or for how to figure out what the regulatory impact or implications are. So that's something to be aware of and to be extra alert if you initiate a new project at this point in time. One sort of the major sort of starting point for this Environment and Planning Act was the idea that environmental issues should be regulated at the level closest to the environmental area where an activity has impact, so the municipal level. That was the sort of original idea of preparing and establishing this new act, which dates back almost 12, 15 years already, this idea. And we find ourselves now in a time with the energy transition, with climate challenges, but also with housing challenges in the Netherlands, where you can see that there is much more a need at the national level to take certain elements and really think about them sort of comprehensively at the national level. So while the law that just entered into force really assumes the competence of the municipal government to set the rules, in terms of policy and new initiatives, you can see that the national government is actually very active regulating some environmental elements. Maybe at the national government level, this Environment and Planning Act has certain decrees that are based on the Act, which regulate also specific activities in the port. And where we used to have the concept of an establishment, which your facility in the port of Rotterdam used to be an establishment with a permit for the whole area within the boundaries of the establishment. We now move to a different legal concept, which is called the environmentally harmful activity, which is quite difficult to pronounce and to remember because it's a mouthful. I would say that for most sort of the larger industrial activities in the port, from a permitting perspective, the changes are not too big. Because for example, the big chemical industry or the activities with large numbers of dangerous substances, they will still be considered sort of one complete package with one permit regulating almost all of the elements of those activities. But if you perform different types of activities, for example, certain storage activities or logistic activities, there will be a difficulty in terms of deciding which activity that I do will be part of a permit requirement and which activity will be regulated by generally applicable rules. And that may differ from the situation before the new law entered into force. So that's something to be aware of. Then there's also another decree that's called the Environmental Quality Decree, and that actually sets rules for the other levels of government when they make their own rules or when they issue permits, and then they have to adhere to those specific rules. So I think that's sort of in a nutshell the environmental regulations at the national government. Then if we move to the provincial government, which for the port area in Rotterdam is the province of South Holland, The provincial government can make, under the new law, a so-called provincial regulation, an environmental regulation really. And the environmental regulation applies to both companies, citizens, and the municipal authorities and the water boards. And the provincial government regulates environmental aspects such as nature, heritage, groundwater protection, and then local railways and provincial roads. And they may, if they want to, also regulate specific requirements for air quality and water quality, and specific environmentally harmful activities that they designate at the provincial level. Then if you go to the municipal level, which is the city of Rotterdam, for the port of Rotterdam, they make environmental plans, which are sort of the new concept of what used to be zoning plans, which may be familiar to many of you. And the new environmental plans, they apply to both citizens and companies, and they allocate functions to specific locations. So basically those plans decide, as the zoning plans also did, which activity is allowed in which area within the port. The municipal government is also the competent authority to regulate environmental elements such as noise, odor, and vibrations. And they can also designate local environmentally harmful activities, and they can set local environmental values, for example, for health, which is something that's new under the new system. And so we're really interested to see how municipalities will handle that and how that may impact activities with an impact on the environment or large industrial activities in the port area. Then the last two levels of regulation are the water board regulation. That's a functional level of setting environmental regulations. So they relate specifically to water, only to water, and water management and water quality, and the sort of water containment or flood protection, for example. And they can make a water board regulation that applies to companies and citizens. And can also regulate from that perspective water discharge, for example, which is a relevant element for industrial activities. And then the last one, but not least, is the harbour master, which is a specific authority in the port area, the port of Rotterdam. And they have set port bylaws that regulate, that apply within the port of Rotterdam and apply mostly to captains and skippers who conduct activities there, and they regulate things such as safety, environment, and services. So then, from the levels of government to all the authorities that are involved in sort of permitting or enforcing all those different levels of regulation, and we try to make it sort of bite-sized, but there's a lot of authorities that you might run into if you do activities in the port of Rotterdam. So just to explain a few of them, at the national level, there's a number of authorities with very specific or specialized competence, such as the Human Environment and Transport Inspectorate, who, for example, regulates transport, well, it's almost self-evident, but transport of hazardous substances, both on road and on water. Let's see, maybe the Netherlands Enterprise Agency is also a very relevant authority, because they are, for example, the party that enforces the energy efficiency requirements that apply to large companies in the Netherlands. But they are also the party that issues many subsidies for energy efficiency or energy transition projects. So you're likely to come across those in your dealings in the Port of Rotterdam. Then at the provincial level, it's the province of South Holland, and the province of South Holland has two different environmental agencies that act on their behalf that you might encounter when doing activities in the port. One is the DCMR, Environmental Protection Agency. They are the permitting authority on behalf of the province for large industrial activities. And for example, they deal with questions such as, do you apply best available techniques in your activities? If the decisions on best available techniques change, you discuss with them about what that means for your process and how and within what time frame you might be able to update your facility. to meet new requirements. And they're also the enforcement agency for compliance with your permit and with environmental, with sort of generally applicable environmental rules that apply to you. Then the Haaglanden Environmental Protection Agency is the authority that you deal with if there's any nature elements to your activities, which there likely is, because if you emit, for example, nitrogen, and you need a permit or you want to determine whether you need a permit for that, then that's the agency that you deal with from that perspective. At the municipal level, it is the municipality of Rotterdam, and the DCMR, Environmental Protection Agency, also represents or also acts on behalf of the municipality for certain topics that are within the scope of the municipality, such as soil protection regulation. In terms of water, there's two, of which Rijkswaterstaat is most likely the party that you would come across most often, because they are the water board that are responsible for the national waterways, of which captures a large part of the port of Rotterdam. And then the Hoogheemraadschap is a very difficult Dutch word, but means water board in a very fancy term for water board. In the Rijnland area, it has competence on sort of the more local waterways. And then, of course, the port with the harbor master that we already discussed before. Okay, so now that you have some sense of what the regulatory landscape is in the Netherlands and what type of authorities you might come across, I just wanted to discuss with you a number of regulatory themes that you might encounter during your activities in the port. One is an overview of regulatory challenges, of which we try to reduce to 4 major regulatory challenges, just in terms of timing and also digestibility. To start with the complexity of the regulatory framework, we just touched upon some elements of that. We have a new Environment and Planning Act in force since the beginning of this year, and this act is a major overhaul of the environmental regulation in the Netherlands. So that in itself, the fact that there is a major system overhaul just means that there's uncertainty, both in terms of, as a company, how to assess what the new rules mean for you, with the authorities who for the first time now have to issue permits based on the new, under the new system, or have to make or change their environmental plans at the municipal level, and everyone is inventing the wheel. So that will take some time, it will take effort, and it will also mean that many different topics will sort of become part of legal proceedings, simply because new legal concepts have been introduced and no one really knows yet what that means in practice. So the Environment and Planning Act, in addition to that, there is still the Environmental Management Act and the Mining Act that regulate different elements of the environment, such as waste management and mining activities. And the Environment and Planning Act itself regulates many different components or environmental elements, such as water, nature, air quality, the Seveso, or sort of the large numbers of hazardous substances and how to deal with them in a safe and responsible manner. PGS is a term in the Netherlands for, let's say, policy documents that sort of further detail how you can organize or what measures you can take in your facility to handle specific types of substances safely. ATEX is the explosion protection regulations. PFAS and REACH for all the chemical elements. So that means that the regulatory framework is complex because it addresses many different environmental components, and they also interrelate. And some of the rules are not really up for that. So, for example, especially in terms of circular development or circular economy, the waste regulations are very strict to ensure that waste is handled in a responsible manner and that it's not dumped anywhere. But if you want to use a waste stream to recycle it into a new product, then obviously you want to be able to be more flexible and look at it as an actual raw material or a product. The rules on when something ends being waste and when it can be a new product are not very well developed. And sometimes these different frameworks that come from a different perspective don't connect very well, and you get conflict of norms on that aspect. Then if we move to the bottom of the figure, to uncertainty of the regulatory framework, is that both at the EU level and at the national level, we have both shifting targets and continuous development in terms of, especially in relation to energy transition and climate adaptation questions, which makes it quite difficult to get any sort of regulatory certainty if you think about long-term investments. And so any sort of investment will require trying to find a good solution for dealing with this regulatory uncertainty. Lead time of permitting is something that is also a regulatory challenge. Can be easily 1.5 to 5 years, depending on the type of project, the type of authority, and whether or not something like that has been permitted before in the Netherlands. And if for your activity you're dependent on grid expansion, so if you need more electrical power to be able to, than you currently have to realize the project, then you might have to add anywhere between 2 and 5 years at least to that lead time, because grid expansion is a very time-consuming process at this point in time. Another, and so there's many initiatives to try to sort of bring the lead time down, to speed up specifically projects that have an energy transition component. But it's a bit of a struggle. So the best thing there to do is to try at a very early stage to make a very good inventory of what is the type of environmental impacts that I have, and how is there any way that I can research that in a good way, and discuss with the authorities at a very early stage which type of permits will I need for that, and then try in coordination with the authorities to make that run as smoothly as possible. There are some coordination possibilities to make sure that all the decisions required for a specific project are sort of taken together, which does reduce lead time. So those are elements that you could consider. And one other element that is also in the Netherlands particularly top of mind is participation. And how the individual is sort of taken along in development projects. It's partially it's a legal requirement that applies in the Netherlands based on the Aarhus Convention, is that you allow participation of the stakeholders in your permitting process. But it's also something that has gotten a lot of attention due to, several things that didn't go very well in the Netherlands, such as the tax fraud situation in the Netherlands. So where on the one hand, there's a lot of initiatives to try to speed up permitting processes, there's on the other hand, a trend that we feel that there should be more participation from the stakeholders in these processes, which tends to make the process longer. So those trends are sort of can also lead to conflicting situations. And in any event, under the new Environment and Planning Act, for many types of projects, there's a participation requirement. So as a permit applicant, you will need to show as part of your application how you consulted the stakeholders in your project. So that is something to really think through carefully and start early. The law is not clear about what this participation requirement entails exactly. So we're waiting to see in the coming years to get more clarity on how that should work. And some local or provincial authorities have made policies in terms of participation, which will help you determine how to best approach that. So then the last bullet is nitrogen and water quality, which have their own specific slides. So let me go to first the Water Framework Directive, which is a European directive which has been in place for a long time, at least since 2000. And it's starting to be very urgent because the absolute deadline to comply with the requirements of the Water Framework Directive is 2027. That is very soon. So what does the Water Framework Directive requires? It requires member states to achieve, such as the Netherlands, to achieve a good status of surface water and groundwater and to avoid deterioration of the quality of surface water and groundwater. And good status means both an ecological status, which is good, and a chemical status, which is good. This has to be achieved by 2027, and that's really, there's no extension possible. And in fact, the Netherlands has already used every extension possibility possible under the directive. And even though we knew already in 2000 that we had to achieve this, we're not ready for this. So the quality of the water in the Port of Rotterdam is not good at this point in time. That's not specific to the Port of Rotterdam because the status of water in the Netherlands as a whole is not good. So if you look at, for example, ecological status, if you look at chemical status, only 9% of all surface water in the Netherlands qualifies as good, and over 90% is not in a good chemical status. And ecological status has sort of different components of what you should meet in order to have a good ecological status. It's a little bit less bad than in relation to the chemical status, but still the quality overall is very poor in the Netherlands. And the Netherlands is also in particular not doing well compared to other European countries. So what does that mean in practice? That means that if by 2027 we haven't managed to reach this good status of all the surface water, it means that will have impact, could have impact on existing activities and will definitely impact new activities. In terms of existing activities, Rijkswaterstaat, the water board authority in the Port of Rotterdam, has a permit revision program because many of the water discharge permits of parties in the Port of Rotterdam but generally in the Netherlands are relatively old or very old and not up to date in terms of best available techniques, and therefore have a relatively high impact on the water quality. So it is likely that if you have a very old permit, then that you will either be addressed by the authorities, that at some point there has to be an update, or you can initiate that discussion with the authorities yourself. But it's likely that within the next years the discussion will be started, whether or not initiated by yourself, to update the current permit. As part of this revision program, and also generally, there's very strict scrutiny for substances of very high concern, such as, for example, certain PFAS substances, which are also under the Water Framework Directive specifically designated as substances that have to be avoided or minimized as much as possible. And another thing that is really relevant in the Port of Rotterdam is the question of cooling water and the temperature of cooling water, where many of the older permits in the Netherlands in the Port of Rotterdam area accept that you can, with your cooling water discharge, you can have at 28 degrees, you can sort of heat the receiving surface water up to 28 degrees in the area where you discharge your water. And that the current thinking is that will have to be reduced to 25 degrees, which may not sound as a very big difference, but in terms of your industrial process, obviously it's quite a challenge. So now if you would request a new permit for water discharge, then you are probably looking at this 25 degrees maximum. And then if you want to do any new activities which require either discharge in surface water, water extraction, or which happen in surface water. So for example, if you want to put floating solar panels, or if you have to put electricity cables in the water for to realize a specific project, then that can only be permitted if it doesn't lead to any deterioration of the current quality of the surface water or groundwater. And given the current status of the quality of the surface water and groundwater, that can be quite challenging. I hope the last bullet of NGO action still has a question mark because we haven't yet seen it, but we have seen certain NGOs that are quite active already announced that they will be starting action in relation to water or water permits. So as long as the quality of the water is not or the objectives have not been achieved, there is a risk that NGOs will either sort of challenge permitting procedures for new permits or permit changes, or that they might submit requests for revoking permits or updating permits to reflect the new situation. So this is definitely something to really take action and not wait. There's initiatives to support you also in that. So the Dutch Industry Association is trying to help both in terms of sectoral research on what are the specific substances that are most of an issue in certain sectors, and how can we address those, maybe also collectively, and also they can help sort of by giving information or liaising with Rijkswaterstaat. So there, and I'm sure that maybe Delta Links or the sorry, I forgot the name of the impact program that you have with where you do also research for specific new developments in the port or to enable certain innovations, that water-related initiatives might also be in play there. Okay, so for me the last regulatory element to discuss with you is what we call in the Netherlands the nitrogen crisis, which has been a long time coming, I must say. And the problem really is that under the European Habitats Directive, the Netherlands has a requirement to ensure the good quality, again, of designated areas called Natura 2000 areas. And in the Netherlands, we have about more than 160 Natura 2000 areas, 129 of which have habitats there that are sensitive to nitrogen, because for those of you not familiar with the impact of nitrogen on sort of natural habitats, nitrogen leads to sort of a richer soil and can lead to more acid soil, and that means that certain types of habitats are really sensitive to that and they might disappear. And that's particularly the case in habitats that are close to the port of Rotterdam, that are in the dune areas. Because those habitats are in particular sensitive to nitrogen, and we have a very high nitrogen deposition in the Netherlands. We have had that for a very long time. Partially that is a result of having very intensive agricultural activities in the Netherlands, most of which are also traditionally have been located very close to the protected areas. But it's also a combination of traffic and industry and using gas in all our housing. So there's many different sources of the traditional nitrogen high deposition. But in the years 2010 to 2015, there was actually a very similar situation as now. It was very difficult to get any get individual project permitted because of nitrogen deposition, and that's why the Dutch authorities try to solve this by designing a program, the Nitrogen Action Program, or PAS, to enable, on the one hand, activities with nitrogen emissions and therefore later depositions in those protected areas, and on the one hand emission reduction programs and investments in order to improve the protected areas. The problem with that program was that where allowing the activities that result in nitrogen emissions that went ahead from the start, there was no real traction in terms of reduction and in terms of nature actual changes or interventions in the protected areas. And this program was annulled by the Dutch Highest Administrative Court in 2019, following a judgment of the European Court of Justice in the end of 2018. And actually, since that time, we've been in a new nitrogen crisis, which also in particular for energy transition projects has been quite challenging. In 2021, the national government tried to to resolve this crisis with a legal solution by introducing the so-called construction exemption, which allowed projects that only cause nitrogen emissions during the construction phase because of the machinery required for the construction, to not take these nitrogen emissions into account in the permitting process. Since that was only a legal solution and not an actual solution in terms of emission reduction or intervention in protected areas, that solution was annulled again in the end of 2023 in the, well, infamous Portas judgment, I would say. Since then, what the authorities have tried to do is they've been working on a new policy initiative specifically for sustainability or energy transition projects, where the first step has been doing in-depth research to show that projects like this, so for example, putting in a heating grid or putting in an electricity grid or a CO2 pipeline, these projects are a prerequisite for making the industry more sustainable. And if you do those, then you allow some nitrogen emission during the construction phase of those projects, but that will lead to a very large NOx emission reduction if the industry is able to become more sustainable based on these investments in energy infrastructure. And so that research has been released in February of this year, and the government has announced that they are working on a way to sort of translate that into quicker and speedier permitting processes for these energy infrastructure projects. And they hope to have a more sort of clearer idea and on how that should work before the summer this year. So that's perhaps a little bit of a high note for me to end this section on challenges. And I'll give the floor back to Bas.
Well, thank you, Iris. That was quite an overview. Very interesting. An overview of all types of legislations and different levels of government who are involved. A lot of regulatory challenges. We are a small country, but I believe we are also a little bit complex. And you gave us an insight in really a crisis at this moment, the nitrogen crisis. And yes, the Water Framework Directive is high also on our agenda. Our NautaDutilh climate program is strongly working on this directive and how to cope with it. And also our department on environmental issues. So thank you very much. We now take the step to a different legal theme, because we want to talk with you about what's happening with the land. So, property law. We have here in the studio David Wemkes. David is partner also of NautaDutilh, and he is specialized in real estate and infrastructure practice, commercial real estate in the broadest sense. So, David, I give the floor to you.
Thank you, Bas. Happy to be here. So, what we see is that obviously sustainability is not only an important topic for the Port Authority itself, but also for the parties that are currently entitled to a right of use with regard to property in the port area. And they have their own ESG ambitions or their own CSRD requirements. And therefore we see an increase of sustainability measures in the Rotterdam port area, very much so. And also due to congestion on the e-grid, we see an increase of requests for battery solutions. We obviously have a use it or lose it situation now currently with the congestion on the e-net. So there are all sorts of additions being made to the current rights of use that we have in the Rotterdam port area. And that leads to certain, well, I try to avoid the word issues, but the challenges is maybe a bit more constructive, that parties should be aware of if they would like to take such measures in making their real estate more sustainable than it currently is. So what I will do is that I will highlight some basic principles that are applicable in the Rotterdam port area. Also, we provided all people currently in this webinar with, I believe, a term list, so that should help because it's a bit technical, so please bear with us on this. So the basic principle is that everything that is being added on land in the Rotterdam port area becomes part of the ownership of the land of the municipality of Rotterdam. So that's quite a shocker for a lot of foreign investors, but the ownership directly falls with the municipality of Rotterdam through a cession, and that's the basic principle that I would like to start with, that the ownership of the land also encompasses the ownership of all that is being added to it in a permanent way. So if you park your car on land of the municipality of Rotterdam, you will not have a problem because it is not designed or intended to be there permanently. But as soon as you build a building on land of the municipality of Rotterdam, then the accession takes place. So the municipality becomes the owner of that property. So why is that important? It is important because we have a more complex property law structuring in the port of Rotterdam, and this has been foreseen, obviously. And to understand the property law structuring applicable in the port area, we would have to go back in history. Then I will go to the first slide, if I may. Exactly. So in January, the Port Authority celebrated their 20-year anniversary already, which was very nice. And the hiving off and becoming independent of the Port Authority became final. Well, how did this go about? The limited company of the Havenbedrijf Rotterdam NV, so the Port Authority of Rotterdam, was being incorporated, and a contribution was made by the, at that moment in time, sole shareholder, the municipality of Rotterdam, and this contribution consisted of the issuance in perpetual leasehold of all land included in the Rotterdam port area. So that was obviously a major step in the hiving off and becoming independent of the Port Authority. There was obviously there was already an exploitation of the port area in place at that moment in time. So you had parcels that were not encumbered with pre-existing third-party rights, and those plots were issued directly, unconditionally, in favor of the Port Authority. But also there was land already issued to third parties in use. And those rights of leasehold in favor of the Port Authority were established under the condition precedent of termination of those pre-existing rights. And also the municipality gave the Port Authority a power of attorney to act on their behalf as owner of the land. So they had pretty much full control. So at this moment in time, we have the municipality of Rotterdam as the owner of all the land, and we have the Port Authority as the leaseholder. Then the question comes up, obviously, what is a leasehold? So a leasehold is to be differentiated from a lease agreement. A leasehold is a right in rem, which gives the holder of the right of leasehold the power to use the property as if they were owner, but there are certain restrictions in this leasehold. For instance, the Port Authority has a very broad right of leasehold. However, the designated use as permitted under the leasehold does relate to port-related activities. So where you have freehold, you have the unlimited use of a property unless you make an impact on someone else's ownership. The leasehold does have rules in which the Port Authority has to be compliant towards the municipality of Rotterdam in their use. So what happens next? The Port Authority issues, in favor of their customers, the users of the land, a right of subleasehold. And the right of subleasehold has a very tailor-made designated use. So where the leasehold contains a designated use, a permitted use under the leasehold, which is very broad, the customer receives a right of subleasehold, which is tailored to their specific use of the plots. And that's where one of the challenges come into play. So please keep this in mind for a later slide. This subleasehold is also established on the parcel of land. The idea is that this subleasehold is being governed also by general terms of use that the Port Authority uses for both lease agreements, where you have a tenant, and for the subleasehold agreements, which are rights in rem. So just to highlight the difference a bit more, a right of subleasehold you can, for instance, encumber with the right of mortgage, whereas you cannot do this with the lease agreement. Real estate transfer taxes do normally in the acquisition of a subleasehold. Obviously, if a tax exemption is in place, then that will not be the case. Also, the accounting principles differ if you have a right of subleasehold or a lease agreement. But what we see with large sustainability projects, additions that are being made with the goal of being more sustainable, that a subleasehold is in most instances vital. Because then you have an operator that comes in play, and he needs, or he or she needs, a project finance for instance, a solar roof. And the banks in the Netherlands still require asset-based finance. So you need a right that you can encumber with the right of mortgage. So that's the reason why, if you have a third-party operator for your project, then you would require a right of subleasehold. And it's much more difficult to structure in a property law sense such a project if you solely have a lease. So this is, I think, the basic principle that you have in the Rotterdam port area. I'm aware of the time, by the way, so I shall speed up a bit. So this is just an interesting slide to show on the left side how those rights are being perceived, from the municipality with the most comprehensive right, then to the port authority with a little less comprehensive right, but also very comprehensive, then the customer who has a right of subleasehold, which is tailor-made to their use, and the operator, who gets a subleasehold, which only has the goal of having and maintaining the addition to the property, for instance, a solar installation. But in fact, as it is being perceived in practice on the left side as stacked rights, in fact, there are no stacked rights. The rights all are directly established on the right of ownership of the municipality. So if you build a power plant or whatever plant in the Rotterdam port area, the municipality will always be the owner. The port authority will always have the most comprehensive right of use you can have through the right in rem of a leasehold. And then the customer who eventually uses this asset gets a tailor-made right of sub-leasehold and has to have the room in this right of sub-leasehold to add certain measures that make the property more sustainable. But in fact, the situation is as indicated on the right. So what I thought was interesting is those general terms of use that are applicable on both the rights of sub-leasehold and on the lease agreements that you would have. They contain certain topics that I would like to briefly touch on. So one of the most important items in the general terms of use is the designated use that is permitted under the right of leasehold, sub-leasehold. And this is the use that is solely allowed. So if you wish to have a deviating use, or on whatever basis, then prior consent of the port authority is required, or else you are in default under your right of sub-leasehold. This is a problem. And also you have to be aware, if you acquire a right of sub-leasehold, which are, by the way, almost always temporary, of a third party, then you have to make sure that the designated use included in this right of sub-leasehold are feasible and are in line with what your plans are on those plots. This is always a subject of due diligence, obviously. Then you have the ground rent, which is periodically due or is paid off for a longer period of time. And if it has not been paid off, it will be indexed and it will be revised after 25 years or as earlier as required by the port authority. And also the general terms contain provisions about the status of the property, as you will have a baseline measurement on the property when you acquire your right. Then at the end of the right, you will have the obligation to remove any such added buildings, and therefore you have to return the property in the status on which you required it based on the baseline measurement. So the status of the property is also, as a baseline measurement, included in the issuance of the leasehold. And also, obviously, the general terms contain change of control clauses, so a sale, transfer, encumbrance, division, or giving in use to a third party will require the prior written consent of the Port Authority. And if you do not, for instance, have this prior written consent of the Port Authority and you wish to anyway transfer a property, then that transfer will be null and void, so it will not actually legally occur. So that's a very far-stretching consequence. And then you have also the liability with regard to the asset. So the Port Authority obviously does not accept any liability with regard to the assets that are located by third-party users, and also the Port Authority receives a waiver for any and all consequences thereof. So that's something to be aware of. So if you have a right of subleasehold that terminates because the period of time for which this right has been established has lapsed, then in principle, if you don't extend this right of subleasehold, you do have the obligation to remove any and all assets located thereon, save for obviously the infrastructure, which is excluded from the rights of use, and that's always with the Port Authority because it obviously has a higher purpose than the sole interest of the user located on the plot. I'm aware of the time, so I will speed it up a bit, and maybe if I can move over to the last slide. So the main takeaway that I would like to provide to the listeners is that if you have a third-party operator for your, for instance, solar installation, you do require a right of subleasehold and a right of subleasehold, and those rights needs to be tailored to also the requirements of the operator themselves. And if you are aware to do or able to do this, then you could have a situation as we have established for WP Carey, one of our clients, with regard to the Nippon Express Distribution Center, where they realized 100,000 square meters of solar roof in the port area, Tweede Maasvlakte, through the use of a right of subleasehold. So it can be done, but you have to be aware of the challenges included. That's it, Bob.
Thank you very much, David. That was interesting to have an insight in the complex world in the Netherlands about the legal situation of leasing land in the Port of Rotterdam. We always say it's not the legal ownership, but a sort of economic ownership which you can get. But still it is complex, and it is well, I think very important for future customers in the port here to learn about it. It is a well-functioning system. Still, it is complex. So thank you very much for this introduction. And I hand over the floor now to Jaco, because it's all about the money. Jaco is a partner in the finance team. He has a lot of experience in domestic, international, project, real estate, and asset financing solutions. So, Jaco, the floor is yours.
Thank you, boss.
I believe you are a little bit in a time squeeze due to the fact that you have to make a business trip. Still, the floor is yours.
Thank you so much. Yes, in this last part of the presentation, I would like to discuss a couple of items relating to the financing of your business and projects in the Rotterdam port. Going to the next slide. Let me see if that works. Yes. One step back. As you all know, the Rotterdam port, as one of the largest ports in the world, presents a lot of opportunities for ambitious projects. For instance, in the building of expansion of terminals, or in the renewable energy sector. However, to secure financing for such businesses and for such projects, it's key to understand what is required to have a bankable project in the Rotterdam port area. Bankability refers to how feasible a project is and how attractive it will be to lenders, investors, and financial institutions. It involves assessing various factors in determining the project ability to generate sufficient cash flow and, in the end, repay debts to investors and financial institutions. On this slide, you see a couple of key considerations for bankability of a project, and due to the time restraints, I will just focus on the most prominent one in terms of this presentation, and that's the first bullet, requiring that a bankable project lives up to the regulatory environment and regulatory requirements which are applicable to a borrower and to a project. This regulatory compliance and legal compliance is a key element for bankability and refers to that the borrower and the project has to live up with the relevant laws, environmental regulations and permits governing the project. It also stresses the fact that in terms of due diligence for a project, the environmental and the identification of environmental issues or challenges have to be assessed and mitigated as much as possible in order for a lender to be able to lend money for a project. Other items on this list are not so much for this presentation, but obviously also very important for being able to finance your project. Most of them are I think, pretty logical, but the technical feasibility and the financial viability of a project are key for being able to start a project. And also, for instance, the offtake. Is there enough demand for your product is key. Last but not least is the risk mitigation mentioned on this slide. If there are risks in a project, for instance, in terms of for instance, grid connection or grid restraints, that has to be mitigated in order to have your project going. Moving on to the next slide is a couple of items which are very important in order to get your project financed. And you see in this slide a couple of key provisions and key elements in the credit agreement in which compliance with laws and regulations are regulated between a lender and a borrower. For those of you who are not familiar with a credit agreement also deals, of course, with the terms on which loans are being provided to a borrower for a project, but it also regulates how lender and borrower act towards each other during the term of a credit agreement. First point on this slide is the representations and warranties. Representations are statements made by a party to another party about facts, conditions, and circumstances. And in a project, you can think about reps and warranties about the borrower itself, but also about the project itself. These are crucial elements of a financing agreement. And in terms of this presentation, it's worthwhile to note that most credit agreements for projects in the Rotterdam Harbour have representations on compliance with all laws and regulations binding on the project and the borrower. It has reps and warranties on environmental laws and social standards, so to live up to those laws. Representations about having all authorizations and permits in place in order to start your project and to have it continuing during the operational phase. And also that those permits are in full force and effect and not, well, able to be terminated. Reps and warranties are typically, and that's also the case for other points on this slide, undertakings and events of default, are typically subject to negotiations in the documentation phase of the financing for a project, and borrowers and lenders will try to see what is a sufficient way to deal with a rep or an undertaking or an event of default for a specific project. You also see in negotiations that reps and warranties are subject to a certain form of materiality, or that certain exceptions are made. Bringing me to the undertakings. Undertakings are promises by the borrower to the lender, in which he promises to fulfill certain tasks and certain items during the lifetime of a loan agreement, which, for instance, also involves having the approvals and the necessary permits for a project to be in place during the lifetime of the project, which is basically also the lifetime of a loan agreement in most instances. As I said, also the undertakings are subject to negotiations in the documentation phase. Important item is also to note is the reporting requirement, which is included in the credit agreement, and which basically requires a borrower to report on, well, financial results of the project, but more and more we see that reporting requirements also shift to reporting about environmental and social matters. So reporting on material incidents or accidents taking place in your project in the Rotterdam harbor, and the impact of such incidents on the environment or social matters. This also applies to changes in your project operation that have an impact on the environment, or incidents of a social nature. You can think about, well, maybe a violent labor unrest or material disputes with or protests by local communities. Part of the reporting is also how to remedy such accidents or incidents. So banks will require a borrower also to deliver a remedy plan and to explain how to solve a problem. Events of default is also listed here as a one to note. When a borrower is in default, obviously a lender has the option to accelerate the loans and to require repayment of the loans. There are all kinds of events of default. The most prominent, of course, are when you stop paying your debt, or when you are insolvent, or you end up in insolvency procedures. But also in events of default, there are requirements to especially in projects, that when a important permit is terminated, or a license is not anymore in place, that can lead to an event of default. So you have to be very careful that all such permits and environmental authorizations are in place and will stay in place in order not to be in default under your credit agreement. Also like to mention that events of defaults also include breaches of remedies and breaches of representations and breaches of undertaking. So, as explained before on this slide, when you represent something to your lender, and well, this representation is not correct, or you don't comply with an undertaking, that also leads to an event of default and can bring you into trouble. Last but not least, conditions precedent mentioned here, because when you close a financing transaction and you want to draw down on your loans, you have to comply with CPs, and CPs also includes delivery, for instance, of copies of permits, authorizations, DD reports on environmental assessment, etc., etc. Looking at the time, and I'm speeding up. Last slide on financing and energy transition. There are all kinds of financing possibilities: project finance, PPP, where you finance together with the government. But we see a lot of activity also in the area of green loans and sustainability linked loans. Just very brief on the concept. Green loans are specifically earmarked for financing of projects with a sustainable nature. There are some key features of the green loans. So the purpose of the loan is that you have to use it for a specific sustainable infrastructure project or other project with a sustainable nature. Borrowers are required to be very transparent and report a lot about the use of the proceeds of a loan. And there's also a verification of such use by an independent third party expert. And banks are in some cases favorable in providing more favorable terms for a borrower. So in terms of lower interest rates or longer tenors of the loan, just to incentivize the green investments. Then very short on the sustainable linked loans. It's a bit of a different concept other than green loans. Sustainable linked loans are focused on the overall sustainability of a borrower and the performance of the borrower, rather than the use of the proceeds of the borrower. Key features of the sustainable linked loans are performance targets. So what are the borrower has to commit itself to predetermined sustainability targets, and to such as reducing carbon emissions or improving energy efficiency in his buildings or enhancing social impact. And also on this concept, there's a lot of reporting requirement by the borrower, and there's a lot of of testing and verification of whether those goals are achieved by the borrower. I think, and that's what we see in the market, is that green loans and sustainable linked loans offer innovative financing for borrowers, and bring also solutions for companies who would like to to commit to sustainability and to improve on that element. That's it, Bas. Handing over to you.
Well, thank you, Jaco, and thank you all three for this wonderful and interesting insight in legal issues in the Port of Rotterdam. Very important, and to my opinion, one of the basics for doing your business here in Rotterdam. So thank you, Iris, thank you, David, and thank you, Jaco, for this information. There is still a possibility to write down your questions within the big marker system, but if you have any questions later on, you can easily send them to us. I believe the contact details can be in screen now. I need them, I believe, 1 or 2 slides further. I hope this works. Not at this moment. Still, all the contact detailed informations we can send to you. I believe this was also in the invitation for this webinar. So if there are no questions at this moment, I would like to thank the audience. I cannot see you, but I'm sure you were there. So thank you very much for listening to this webinar, and hope to see you soon on another subject. Thanks to our colleagues of NautaDutilh, and hope to see you soon. Thank you very much.